Please give us a brief introduction.
I did my 10th and plus 2 from Anshuman-Aarohan English Medium School in 2012 and 2014 respectively. Then I completed my graduation from National Law University of Odisha on the BA LLB honors, and then I completed my LLM from National Law University of Odisha itself, and I am continuing with my PhD from SOA National Institute of Law. And also with that, I am currently working as an assistant professor in SOA Institute of Law.
Okay, fine. So, what is your name?
My name is Anshuman.
Anshuman?
Anshuman-Aarohan.
Anshuman. Okay. And tell us something about your hobbies and your achievements.
Yes. So my hobbies are writing sonnets. Sonnet is basically a 14-line long poem, and with that, I am also a fascinated. Yes.
Please tell me.
Also, I am a great admirer of reading non-fiction books. With that, my achievements are of I'm a winner of Google Startup Weekend in 2018, and also I am qualified of UGC NET into December 2022 by
Google certificate for what?
Google Startup Weekend.
Sorry?
Google Startup Weekend, a program for entrepreneurship
By Google.
by Google. Yes.
Okay. So you are into entrepreneurship. Why are you interested here?
It was a competition where I wanted to check that what all things I am good at. Am I good at managing the people? Am I good at persuading the people? Am I good at taking right decision at right time or not? So that is why I had joined this competition, and fair enough, I won it.
But then the basic qualities and the instincts of an entrepreneur and the basic qualities and instincts required for a civil judge are completely different. Civil judge has to be like within the box kind of thing.
Right.
Even if he sees that there is some problem, he can't think out of the box and he can't do anything out of the box.
Right, sir. Right.
Entrepreneur, on the other hand, is completely free.
Right, sir.
Because ultimately whatever will happen, it is his own at his own risk.
Right.
So if he succeeds, society will gain. If he fails, society loses nothing. It is his personal loss. So then how did what are the reasons that you decided that no, I'll be going into academia? Currently also you are assistant professor, you have qualified UGC NET, you are doing your PhD.
Yes.
So in a sense, I can say both academically and financially, you are quite settled. So you give us some very convincing reasons why you are interested in coming to judiciary.
Right. Sir, actually, the moment I joined National University, I was having this keen idea that I want to pursue judiciary, and judicial officer is my only ultimate aim. But I also wanted to try each and everything that has been given to us in our course curriculum. So in a co-curricular activity, this was one of the competitions which were asked to participate. And simultaneously, by God's grace, I could win it. And regarding academics, joining academics was, I had two reasons to join academics. First is that I want to become financially stable. Meanwhile, I am practicing for judiciary, or I am opting for judiciary. And secondly, I wanted to be in touch with those subjects which are necessary for cracking the judiciary. So the only reason, these are two the main reasons that I have joined myself in academics.
Okay, Anshuman, you have not tried in any firms?
Actually, ma'am, I always knew that I wanted to go for judiciary, and making myself open for firms would make me away from this judicial subject. Hence, I didn't opt for a firm because from starting itself, I wanted to be a judicial officer.
Okay. And God forbid, for any reason you are not able to crack this time, what are the future plans?
I'll be continuing with those subjects and try to figure out what are the probable odds that I couldn't make it this time. But I'll give again next time because this is the one thing that I wanted to do.
Yeah. Okay. Now, tell me something about judicial activism. What is your viewpoint about that?
Since our system of judiciary has sustained this fact called due process of law. Now, due process of law, something that judges take into charge whether the particular law is basically it has become fair, reasonable or not. So, hence, judicial activism is necessary to sustain a particular a society into a good well-being. So judicial activism is necessary.
Okay. Now tell me that you are very much into the academic field. Okay. So do you support this idea that we will, can we think of just not, I'm not telling in the very detailed way, but in a superficial way, can we incorporate legal teaching in the school levels?
Definitely, madam.
And whether it will be beneficial or not?
Yes, definitely. Law is something to common people. And when we are understanding the word law, it involves each and every sector of our society. And from starting to kids to grown up, all people require law each and every day, every moment. And for that, everyone should be aware of their rights and duties. And hence, this education is important.
Okay. Madam asked you something about judicial activism. Related question. There's a very fine line between judicial activism and judicial overreach.
Right. Exactly.
And lot of people from the executive and legislature side, the last 5 to 10 years, are not very happy with the judiciary taking up, according to them, their space. Okay. So, as a judicial officer, what are the things you will keep in mind? Okay, so that even if you go for judicial activism, that does not, go to the level of judicial overreach.
Right. So, the main thing which a lawyer, advocate, and every person of the society should focus is constitution. So I think that being a judicial officer, the first and foremost important thing which I need to keep in my mind is constitution. So I will always abide with the rules and regulations that has been given by the constitution, and also keeping the fact or the factor of constitutionalism with that, which is the spirit of the constitution. Hence, if I keep both these together, then I don't think that I will be hampering the judicial overreach.
Okay, that is fine. So today we will, from the legal side, I'll be basically concentrating on your procedural laws, CPC, CRPC, and evidence. Okay. So can you tell me what is the concept of plea bargaining? What are the advantages and disadvantages?
Yes.
And after we have implemented it in India, have we seen a substantial reduction of the caseload?
Right. So plea bargaining is basically given in section 265 of CRPC from A to I am not able to maintain the section name as of now. But in plea bargaining, it is basically we are trying to negotiate our basically if a accused or a convict is trying to negotiate exactly what will be his punishment for. Since our India is formulating the theory of punishment, a reformative form of punishment, hence plea bargaining is necessary, sir. And systematically, we haven't seen a very huge downfall of cases, but still it will be help those convicts to reach to a particular position, because it will help them generally to just clear out the backlog of clear out the number of days in the prisons, and will help them to start or refresh the life after getting out of prison. So this may help them.
Okay. So, under the CRPC, you tell me what are the provisions for a common private citizen to arrest an accused? And after arresting, what is he supposed to do?
Yes, sir. Sir, exact section
Is not required. If you don't remember, it's fine.
43 or 44, I don't exactly remember. And also in 39 section of CRPC, it is being given that first in section 39, it is given that the village will be aiding to the police officer in arrest of any person who is supposedly accused. And in similarly from the arrest chapter, that is section after section 41, it is said that a person, when he sees any person committing a cognizable offense in place of his in front of his eyes, he will be tracking him down and immediately send him to the nearest police officer. He can work as he can arrest that particular person at that particular time.
Okay, fine. So, under the Evidence Act, the government has proposed amendments to 3 major acts. You tell me at least 2 important changes which the government is making for the current Evidence Act.
Evidence. Okay. So, as of now, what I have read, but I'm not able to recall whether it is from Evidence Act or not. But once it is that before the accused statement or the statement of people who were not recorded, or the statement which has been taken earlier were not recorded, but from this amendment, it will be taken into consideration for video recording all this in a video recording mode. Secondly, I could see that as I've read, exactly I do not remember it, but they have also a system where it is imposed. Where it is imposed, possibly they will be including mine. Sorry, I'm not able to recall it now, exact provision, but this one I can say it properly.
Okay, fine. That is correct. What you have said is correct. What do you think? Why they have done this? Why the video recording?
That's it. So here, as per section 161 of CRPC, it is being seen that whenever a statement is being recorded by police officers, since they cannot sign it, ultimately when these witnesses are being called to the court, they just say that we haven't made such witness or we haven't made such remark. So it will help the police officer in investigating further, and also tell court that these people have said this particular analysis. Yes.
Suppose they say that the witness, they go to the courts and say that we were under duress and we under compulsion, pressure, threat by the police, we give this. Is it going to change the type of the admissibility of evidence given to a police officer in front of the court?
So it may not change it, but it may help to keep something in substantiation. Why? Because when we are considering somebody's witness or somebody's statement, these statements are to be taken into a serious condition. So earlier, if somebody is making a statement, police has noted down, he may note it down in a wrong manner, or the other person who is making that statement, that may be false. So to testify it, such video recording is necessary, sir.
Okay. Do you know anything about the witness protection program which India has? Does India have a codified or based on any statute a comprehensive witness protection program like the European countries or US has? And suppose you are asked for your recommendations. Okay, what would you suggest? How to protect the witness?
Sir, exact provisions I don't remember about witness protection, but I do understand this fact that whenever a witness is requiring police protection, he will be availing it. Because this is something it is given in Article 21, because right to life is in threat, sir. And simultaneously, my suggestion would be that when we are providing witness some kind of benefit or some kind of protection, there will be more people coming into this feature when some crime are coming to place, because there is threat to the life and threat to the property. That is why many witnesses do back out at the main time during prosecutions.
Okay.
Okay. Now tell me, this is your first attempt?
Yes, sir. Yeah, no, ma'am. Previously, I had attempted for prelims, though I may not be in a correct format at that particular time, so I could qualify that.
Okay.
The interview is first.
First attempt. Okay. Now tell me that suppose a case comes to your court which involves the traditional culture being prevalent in a particular place and the law. There are two sides, and you are going to give your verdict. How this is the traditional laws will affect your verdict?
Traditional law. Basically, as per Evidence Act itself and other provisions of Indian law, it is said that any tradition, usage, or any laws familiar to giving certainty to the customs, it all will be availing its power from constitution itself. If it is affecting anybody's constitutional right or any fundamental right, then I will be definitely giving the judgment against them, because constitution is supreme in this country.
Okay. Nowadays, in our society, we are facing on major issues with that we are encountering a lot of people with cognitive disabilities.
Right.
And if such a case arises where the person, one of the accused or the victim is a cognitive disabled, so how will you give a verdict? How, on what basis your verdict will be based on? What are the things you should consider before giving the verdict in if a case of cognitive disabilities, because you know it is very much increasing day by day in our society right now. So it also will be going to the court of law. It is going and it will go.
Right.
So what are the things you should consider before giving that verdict if you are a judge in that court?
When it is about verdict, I will ensure that whoever has that cognitive disorder, they understand the course of verdict. Whether the verdict which is being given is being understood by that particular person or not. Similarly, I will also ensure if that particular person is in the position of convict, I will also ensure whether he has that particular intention or not while doing that crime, or does he understand actually what are the consequences of this or not. So after taking all this into mind, I will make a concluding remark, and I will also ensure that he understands what the verdict is. If he is not able to, then there are certain rules and regulations that is being given by the constitution itself to not consider them as accused of contempt.
Okay. Now tell me that like a high profile case has been coming to your court, which has a lot of media attention, and social medias are playing a major role. All these things are happening, and it's happening day to day.
Right.
You know? So as a judge only, not anybody, but specifically as a judge, how do you handle this pressure?
I think judges should not be mesmerized or very much get affected by this all verdict, because there are several instances like our Honorable Supreme Court Chief Justice D.Y. Chandrachud has already said that this high profile case won't. I have seen in all the cases he generally take every cases as a same matter with same reference and same intention that he takes others. So I don't think judges get affected due to this high profile cases.
Okay. And in Odisha, we know that in the ascent of ODI is diversified in the different districts of Odisha. So do you think incorporation of local languages in Odisha courts will be beneficial, or it will find some, means it will create hurdles?
Definitely, ma'am. For some, it may create hurdle, but it will be beneficial to the masses, because since Supreme Court has already described that this all the judgments of Supreme Court will be converted into 4 languages, and among them ODIA is that, and I think this is a high time to consider it for ODIA as well. But with along that, there should be provision for English also. So translated version should be of ODIA. Along that, there should be English, so that each and every segment of a society will get benefit by this judgment.
Okay. Can you tell me, apart from appointment of judges, which is a basic question, how do we establish speedy justice in India?
There are certain provisions provided in cases like Anwar Ali Sarkar versus State of West Bengal. They have already mentioned that in order to have a fair trial, you can have special cases or special segment of cases under the special classes of courts to ensure speedy justice, like for rape victims or the acid attack victim. First track courts have been established to ensure speedy justice. Similarly, in case of minor rape victims also, the cases will be done within a matter of 2 months. Investigation will get over. So this is also given under CRPC. So these are some of the instances where we can ensure that speedy justice is provided.
So, tell me something that you know about rest basically.
Resisted. It is coming under Section 6 of Indian Evidence Act, where it is about circumstances. It is about connecting those circumstances and keeping into one particular coil, so that it could finally come into a particular line where we can understand it as a totally circumstantial evidence to prove those circumstances where accused can be considered for convict.
Okay. Under the Evidence Act, so what are the exceptions to dying declaration? That means when the court will not accept dying declaration as a piece of evidence.
Sir, as of now, I am not able to recall it, but if you allow me, then I can try. Sir.
Yeah, please.
So, Section 174, one speaks about exception of dying declaration, but I'm not able to recall it what exactly it is.
So suppose I'm going by the side of a road and there is an accident. Okay, that vehicle has hit this person and vehicle has sped away. So I go to attend that person. That person now is in a very critical condition, and he gives me some information that the person who hit me, it's not a hit and run accident. He is actually known to me. So we have had a dispute. I think he has intentionally done this, and while taking him to the hospital, he dies. So, and I tell the same thing to the police. Okay, will that be taken as a dying declaration? So, and there is no one else to corroborate that. I was the only person present there.
Yes, sir. So yes, in that case, it will be a dying declaration. But if there is a sufficient sufficient proof to sufficient evidence to prove that this is the only thing which could be presented as a matter of substantive piece of law, and other, like for example, if there is CCTV camera which shows that this particular person was not involved. So that is also can be a substantive piece of evidence where it can counter that dying declaration. So
It can be disproved.
it can be, but basically it's a substantive piece of evidence, but it can be disproved.
Suppose the other party means the person whom this person accused that he's driving and all, he is unable to produce any evidence
Yes, sir.
that I was, no alibi, nothing. So only based on my statement, okay, can the sentencing being done?
If if the court thinks that there is no other sufficient ground to prove whether this dying declaration is inconsistent or not, then on that basis, this dying declaration will be taken into consideration.
Suppose the defense brings in some evidence that I have been involved in domestic violence against my wife and all these things, personal things. I've been convicted for that also. Will it change the quality and admissibility of the statement which I'm giving in this case?
So it depends on the facts and circumstances, but I don't think it will change the quality, sir. Because he has been already convicted for that. And since he's already has got the punishment, then I'm not able to say it properly, but it may be.
In a criminal case, prior character or prior, let's say, behavior, does it matter?
In case of bail, yes, it does matter. And in case of procuring bail, and in case while convicting, there's in the provision of judgment, I'm not able to recall the exact section. It may be 354, which speaks about judgment, where they will check that whether prior conviction was being done or not. And if he is a habitual offender, then he might get a higher degree of punishment.
Okay. So you know about Article 370?
Yes, sir.
So what is your opinion 370? Article 370, now the hearing is going on in Supreme Court today. 370, in your opinion, that it was abrogated, or at least it was watered down, that is good? Or you think that no, that we should have allowed that some special privileges onto the state of Jammu and Kashmir?
Exactly, sir. So in this judgment itself, and recently in today's date also, the judgment or the verdict has been made, and here the D.Y. Chandrachud had also said that basically this temporary provisions is correct, removal of temporary provision is correct, and also in my opinion, I also understand that when there is a nation, whenever such provision are to be removed, and if it is taken into consideration, all the process that can be done in that particular time, then it is correct, sir. Because all the provisions that has been given as per Article 370 are being taken into consideration.
Are you aware of an act called the Places of Worship Act?
Yes, I am aware of that.
Okay. But do you think that, there is, first tell me the context, what is that Places of Worship Act? And do you think in a secular country, such acts, need to be honored, or it should be repeated?
Please, basically, I am not exactly aware of the.
Okay, let me give a context. Places of Worship Act basically states that the different religious places of worship,
Yes, sir.
that character, okay,
Yes.
Post-independence can't be changed.
Yes, exactly. But I was coming to that in relation that it was after Babri Masjid's demolition, and it exactly I'm not able to say what all provisions are there, but as per places of worship act, it is said that if after 1947, whatever places are of some religious shrine, they cannot be demolished or they cannot be challenged. But sir, in my opinion, it is the situation now that there are several instances where when you dug up the particular when you place, you find the remains of that particular history. So I don't think that it is a bad thing to get away with these places of worship act because other religious sentiments are necessary.
Hmm. Okay. Um, right. So my last question to you would be, how do you handle failure? Suppose not in civil, I mean, judicial services, maybe in anything, generally, in life and all. So suppose you had planned something today, you had to read this, and you had to do this and this. But some very old friend has come and entire day, okay, you have spent with him. So whatever you had planned, you are unable to do it. So how do you then, how do you handle, suppose considering this that, okay, I could not, follow what I had planned. How do you then, deal with that? Or in other words, if I can just extrapolate it, in general, how do you deal with failure?
Sir, failure is a state of mind. So if I feel sometime, and being a person, I may feel being failure at some point of time. So when I feel that I have failed. So for that particular time being, I may crib about it, but that will not last for longer because at the next moment I'll again plan how to overcome that failure, sir. At the example which you gave, whether for example for my friends, I have utilized the time, and I did not do my work. So in that particular time I will basically work for a longer period of time when he has left, for a longer period of time to try to finish that job, and if it is not done, then I'll keep it for extra work for the next case.
Okay, fine. So that will be the end of the interview.
Thank you.
Now, the feedback.
Correct.
So my feedback is basically, first thing is that your, this in our body language terms, if you sit with this like clasping your, hands, that is basically you are expecting support. Each hand is expecting support from the other hand. So it is a like nervousness, sign of nervousness. So you can, place your hands on your knees or legs depending on your height.
So actually, I was flashing it because I have a very bad habit to express it and move my hand.
Hand movement, no?
I'm a teacher, so
Okay, it will be there. So what you can do is you can try to lock it. Okay.
can I get it like this?
On your knees.
This.
Yeah, that would be fine. So it is locked there. Generally, you have to practice that it does not.
It may move, so that is why I clash it so that I do not try to speak.
You try to do it. Try to do it.
I'll do it.
Okay. And
So sitting posture is
sitting posture is fine. Only that part we need to work on. Okay. Eye contact is good. Okay. Smile was also, it was okay, but the more, you can, it has to be maintained. Okay. The smile has to be maintained. Another thing is like while confirming, like someone is asking you some question, you have understood it. During confirmation, you are saying yes. Okay, yes, sir, or yes, whatever. So that we can do just like now what you did, okay, by nodding. Okay, rather than saying yes every time. So that is one thing. Rest other things, I think it's quite good. Your domain knowledge is good, but then thing is that you have to have some very good reasons to convince them that why you are into judicial service. Okay, since you are writing that you have been a Google entrepreneur and
I'll not write that.
no. That is, you should write. That means they are getting a versatile person.
Okay.
Okay, they're not getting a bookworm.
Okay.
Right. So someone who can think out of the box, because tomorrow judiciary has to think out of the box. It's simply not possible to have this kind of delay. So suppose they would be planning, we will make a committee how to integrate artificial intelligence in decision making at the judicial level. If they have someone who is, from their own fraternity, it really helps.
Correct.
Okay, there have been people from Infosys and other IT companies joining judicial services, right? So it's you should write. Some people think that if I've achieved something, I'm doing PhD, I'm doing LLM, I'll not write that. They are confirming that. Last year, what happened? So some people had not written that we have done LLM, but either they were pursuing or they had finished. Okay, so when they saw, especially member secretary of OPSC, that was his job. He just asked them one by one, hey, you've done LLB before 4 years. You've not done LLM. Then what do you say at that time? Yes, sir, I've done, forgot to write. Answer that. So now the questions will start, they'll start asking questions in a different manner. Okay, so that is first impression is the best and the last impression in these cases. And very, even compared to the civil service interview, here you are having a sitting high court judge. Okay, so if you say that 10 questions, I'm unable to answer 9 questions, that's still good. And 1 question you answer well, out of 100, you will get 60, 65. If you try to bluff or try to, go around them, then it will be very difficult. Okay, but I'm very sure you will be getting top 10 percentile marks in the interview, and I'm expecting that you will surely be in the list. Okay, so I have given for today.
Okay, one more question that might be coming. I don't know whether they are aware of that you write sonnets. So they will be asking who is your favorite
Who popularized sonnets? Particularly with whom do we associate sonnets?
sonnet with?
Actually, sir, sonnet is something like that. I have grabbed my interest of my own. I don't generally
Go through that. We have
I will go through.
Shakespeare's sonnet.
Shakespeare's sonnet is not as
Very famous for his
Sonnets.
as poems.
Sir, but Shakespeare's sonnet, I don't like it. So that is
You don't like it, but the initial word of sonnet,
Achha,
like that.
okay, in that case,
In
okay.
like in this poem, I don't remember that name. That's something, but in sonnet 3, sonnet 18, something is there. You can also take the name of William Wordsworth.
William Wordsworth is my
He
favorite.
is,
Yes.
he is
Road
also
not
an-
again.
yeah.
Yes.
You can have a sonnet. Okay, so a lot of people does not know what the difference between sonnet and a ballad and a lyrist and rhyme. So they won't go into that detail, but a superficial things come. What is sonnet? Who is writing that? So that comes to a mind, especially when this comes.
Right,
Okay.
right.
So just go through that. If you say William Shakespeare, well, you say it starts from William Shakespeare. Don't say we don't like you because he's also written down first. You know, Wordsworth, you say, okay, I love this particular sonnet of Wordsworth.
William Wordsworth,
yeah.
Road Not Taken is my favorite.
Yeah, so you
And also Rudyard Kipling
yeah,
also.
yeah. So you write Kipling is a very modern day word which people must have heard if they are in the panel. Now coming to you, what I have given you a bit less so that you can have the scope for improvement is 76 out of 100. Why? Let me tell you. You have a clarity of answers. As you are a teacher, you are very much touched with the subject, so that what is the reason of being a teacher you told. As sir told that justify why you want to be a judge, because academics and judiciary are two different things. Here you have a complete open mindset. You speak with the students, you sit with them, you are more accessible to the public. There you are more constrained from the public. So that is the reason why you are skipping from one end of one side of the pole to a diametrical other side of the pole. Okay. Now hand movement should be minimized, because as teachers also we understand it becomes but we can practice. Actions are animated, like whenever you know the answers, if I close my ears, I can know that you know the answers through your face expression. You should be smile and composed. Okay. That's the thing. So it can be controlled, and that can be controlled, as sir told, if you give lot of mirror. Have you means your classes that is okay. Mirror interviews, you have to give sir will tell you how to put the mirror interviews. Take away the way. So that you can know that how your face looks while you give the interview, and you can only rectify that. Okay.
Yeah, in some cases it is a little bit more.
Yeah.
So tonight you get the recording, just go, just do the recording.
It should be composed. So that will be the
More
balance.
Okay, yes. So that will be the end of the interview. Thank you.